Trump gagged again. Judge Chutkan says, we're not waiting for the Court of Appeals to say whether my original order is valid or not. You, sir, are gagged. And she was not happy with a couple of posts that he made over on The Truth, talking about Mark Meadows and some other people, because remember, she actually lifted the gag when he appealed it. She said, you're gagged. He said, well, I'm going to appeal it though. And she said, well, if you're going to appeal it, then I'll lift it. And then he submitted a basis for keeping the stay, keeping the lift. And she said, no, not good enough. You're going to lose. Gag comes back. So we're going to go through what Trump's original order was, or motion was, before we get to the order, because Trump already responded, man. He's on Truth Social, just dropping off bombs right after the gag order came into place, but he's being very careful about it, right? He's not some of the same things he was saying before, seemingly in line with the gag order. So we'll go through all of what happened here, starting off with the Trump reply. And remember, the way these things are structured is Trump makes the original filing, which he did, then the government issues a response, then Trump gets the final word in the form of a reply. So this is Trump's reply in support of a motion of a stay of a gag order. Now, you might be asking yourself, Rob, if we already know what the outcome is on this case, why is this important? Well, it's because these arguments are going to make their way up, right? We're going to see these arguments again. In my opinion, I think the Supreme Court should settle this, right? We should decide what has priority here, Trump's First Amendment rights or the due process within the criminal court system, or how do we balance those things, especially when you have a real serious risk of taking a political candidate and harming their political campaign using the justification of the criminal courts to do it. So Trump responds to this, and this is kind of his final word on this. He says, look, all right, Judge Chutkan, you issued an order and you put it in the docket. We are going to call it the gag order. Now, what that does, Judge, is it imposes sweeping prior restraints on Trump. In other words, Trump can't speak because he is restrained before speaking. He's muzzled. We know he's the leading candidate in the 2024 presidential campaign. So if you reinstate this gag order, the gag order would prohibit Trump from discussing nearly anything about this case. And so I just want to pause for a moment here, because in criminal law, sometimes you can have a bad ruling that goes against you. You can have lose a motion to suppress, lose a motion to dismiss, lose any type of issue. And you can appeal it at the conclusion of the case. And the only thing that loss really impacts is the case, right? It might impact other things, like a person's necessity to go to court, like to show up for another trial. If you reverse it, if you have a mistake in the original trial and you reverse it, you might be able to do it again. It's going to cause that person to have to go through a trial again and all of those things. But that person is not going to lose, in some instances, a presidential election, okay? You can't undo that. If Trump is gagged here and can't comment on the election, yeah, he might be able to have a new trial again when Judge Chutkan gets reversed on appeal, but he's not going to get a new election again. So we're talking about serious collateral external consequences from this. Okay, Trump is being harmed in a very palpable way beyond this case, and this is impacting that. So they say this is a key campaign, Judge, and with the American public, including reasonable foreseeable witnesses and their testimony, we want to be able to talk about this stuff, and your gag order would limit Trump to that. Reasonably foreseeable witnesses is so broad, it encompasses virtually everybody. Also limits criticisms of prosecutors, whom he believes, Trump believes, with good reason, by the way, are politically biased, as laid out in the prior document, the motion to dismiss for selective prosecution. Trump's defense says, Your Honor, never in American history has any court censored the speech of a political candidate, least of all in the extraordinarily broad and vague terms of your gag order. In reaching this unprecedented decision, the court rejected and did not rely on any of the prosecution's false, unsupported, and unconstitutional claims that prior restraints are necessary to avoid undermining the confidence of the criminal justice system, or otherwise influencing the actual outcome of a trial or prejudicing the veneer. Instead, rather, Trump's defense says, the court's sole justification, the only reason, all those other things were necessary, but the sole justification is its unsupported conclusion that President Trump's protected speech about this case may lead to some third party out there threatening and harassing the prosecutors or the witnesses or the court staff. It's all hypothetical. It could happen. The prosecution echoes this theoretical and this conclusory argument, right? So they're saying what it could happen. Trump says a lot of things. He's got a big audience. This is like if you're a big social media influencer, like you have less speech because somebody might do something crazy out there. And this is the law of big numbers, right? That kind of is how this works in many ways. So they're gagging Trump to stop that. That same possibility. The idea is other third parties could be threatened by anybody's statement or take action that is threatening based on anybody else's statement, not just Trump's. But here's the point. They say, as discussed, Your Honor, this purported reason for the prior restraint is entirely unconstitutional. Neither this court nor the prosecution allegations suggest that President Trump himself has threatened or harassed anyone or directed anyone to do so. The only cited concern is the unidentified, quote, followers of President Trump, numbering over 100 million U.S. citizens, okay? So you just think, like, what's 1% of 1% of 1%, right? There's like, a bunch of people in that number. May do so unprompted at some future date. So it's anybody who's popular, they can kind of gag based on their theory, right? That somebody might do something someday. So they say, thus, the relevant questions on appeal are the following. One, whether the court, this court, Chutkan, and this is the kind of stuff that's going to go to the Supreme Court, and we're going to probably see these issues reappear at that docket. Whether the court, meaning Judge Chutkan, may prohibit a leading candidate for president from commenting on critical public issues relating to his defense of this case out of a concern for what unsolicited third parties can do. So you kind of break that out into two things. One, can the judge limit the leading candidate from commenting on issues relating to his defense? Is that even allowed at all? And if so, what is the threshold? What justifies limiting that? Because remember, the First Amendment is our safety valve. It's our pressure relief valve. When things are going bad in the country and all the powers that be leverage the powers in the institution to become corrupt, the only way to challenge that is to be able to speak about it and rally people to your cause and call out the injustices and shine the spotlight down upon it to bring accountability and transparency. So that's why they want to gag you. That's why they're going to want to keep cameras out of this courtroom so that we can't see what they're doing. Now, whether the evidence presented is sufficient to justify one of these content-based restrictions as measured by the appropriate standard, and whether the gag order is narrowly tailored because this is Trump's constitutional right, accounting for invariable constitutional prohibitions on vague or overbroad prior restraints. So, Your Honor, you're going to have to answer all of those, and we'll see what Chutkan says. They say President Trump is nearly certain to succeed on each one of these arguments. SCOTUS, the Supreme Court, has held time and again that a person may not be prohibited from speaking because of the unsolicited actions of others. Otherwise, we would never speak. If every time we said something, we might be liable for some other person's actions, why would you talk about anything? Because somebody can just say, well, I mean, I got the idea from Rob. Well, what idea? Well, I don't know. And maybe they didn't get it from me, but they can say they did, and I'm liable for that thing? It's like, we don't want to speak at all. People are responsible for their actions, not the other people who say something about it, right? We draw the line there. Rather, only speech directed, specifically directed to inciting or producing imminent lawless action is likely to incite or produce such action may be censored and is likely, right? So it's a two-part test from the Brandenburg test. If you say something, are you intending it to incite or to cause imminent lawless action? Like, is the speaker intending that? And is that speaker's statement likely to actually cause that action? Okay, if, for example, some homeless person, okay, is outside, of the court building screaming, down with the court, right? Maybe he's saying, take the court over, or saying something, right? He's inciting it. That's his subjective belief that he wants that, but it's not likely to incite anything, and we still protect that. So it's got to be directed and likely. Then it may be censored. So Trump would have to be very specific, right? Intending to cause something like that. Now, moreover, whereas here, the speech at issue is inextricably political, the Constitution holds no tolerance for censorship. President Trump has a right to speak his mind, and the public has a right, we have a right to hear what he has to say. The prosecution and the court may not like the content of these statements, but Trump has an inarguable and inalienable right to make them. Nor is conceded prosecutorial speculation from Jack Smith and those deranged thug prosecutors that some individuals might feel harassed or threatened is hardly a constitutional justification for limiting free speech. Because Molly and the highlighter team, they're all freaked out about this or something. We're nervous. Well, here, without clear and present danger, according to this U.S. Supreme Court case, or even a substantial likelihood of material harm, the gag order will not be upheld on appeal, is what Trump's defense says. And finally, the gag order is not tailored at all, let alone narrowly. When we suppress somebody's constitutional rights, it has to be necessary by the government. There's like nothing else they can do. And it has to be the most narrowly tailored thing possible, right? They can't be overbroad with it. So this is not tailored at all, let alone narrowly. It uses undefined, ambiguous terms such as, quote, target, that arguably and, quote, unconstitutionally encompasses essentially all statements regarding this case, no matter how innocuous, unless they fall within three narrow and equally vague safe harbors. The gag order is anything but narrowly tailored and precise, and it is therefore unconstitutional. As the gag order is highly unlikely to survive appeal, Chutkan should stay its application pending a decision from the D.C. Circuit Court. Doing so will prevent irreparable irreparable harm to President Trump and his First Amendment rights, and that irreparable harm is the election, right? If you can't comment about the election, I mean, the FBI and the DOJ and the weaponization of our government is one of the biggest issues in my mind in the whole country, because if you can't have a system of justice in your country, how can you have a functioning law? You can't, because somebody can break the law and there's no justice as a result of that. So they say cause no cognizable harm to any party, and this serves the interest of justice. So lift the gag. Now, the government says, Jack Smith and the deranged thugs over there, they repeatedly insist that President Trump's speech must be gagged because in their estimation, it might, despite not requesting or even encouraging such conduct, it might cause independent third parties to, quote, threaten or harass others. Now, this is something that we've talked about in the law, okay? This concern, which our case law describes as, quote, the heckler's veto, cannot justify censorship. Just the opposite. Even where an audience might react with disorder or violence, this is a quote from a case, even when they might react, the Supreme Court repeatedly rejects the government attempt to censor. Brown versus Louisiana, Cox versus Louisiana. They say the constitutional rights may not be denied simply because of hostility to their assertion or exercise. So you can't go out on a street and take a position on what's happening in the Middle East without being attacked or something like that. Your rights to free speech are, under oppression now, and you can't go out and speak about abortion or about elections or about Middle East stuff and carry flags around. You can't do any of that if your speech might cause disorder or violence. Is this what we want as a standard in our country? Trump says something and it might be disorderly, okay? Other people say something and it might be disorderly, therefore they're gagged? That's insane. What kind of country is that? There is no free speech. They say, now, as to the possibility of there being hostile audience members causing violence, the law is quite clear that censorship considerations are impermissible, okay? If they get violent and they start attacking people, that's on them. Trump's defense says the prosecution devotes only a single sentence of its garbage brief to this fatal problem, arguing for the first time that the court must silence Trump's speech not because of violent disagreement of the audience, but rather a clear pattern of a portion of the audience actually agreeing with Trump's implicit wishes, is what they say. But the prosecution cites no authority to support this distinction between the risk of unruly disagreement and unruly agreement, and none exists. In fact, the government's argument directly contradicts the Supreme Court incitement cases, which plainly instruct that the speech falling short of incitement may not be silenced solely because it might inspire crimes or violence by those agreeing. If your speech falls short of incitement, the incitement test is the one we talked about previously. The speaker intends it to cause some lawless action, imminent lawless action, and it actually does, or may result. So if it is short of that, it may not be silenced because it might inspire crimes. Now, these decisions have fashioned the principle that the constitutional guarantees of free speech and free press do not permit a state to forbid or to prescribe advocacy of the use of force or of the law violation except where such advocacy is directed to the Brandenburg test. That's when they can come in. This is according to Brandenburg, the U.S. Supreme Court case. So they say, Your Honor, Chutkan, under settled law, a speech restriction that seeks to silence speech because it might, quote, provoke the use of force or of law violation from the audience. If you try to silence and censor Trump for this, it impermissibly intrudes upon the freedoms guaranteed by the First and the 14th Amendment. It sweeps within its condemnation speech which our Constitution has immunized from government control, citing 8 cases here. Now, here these cases are controlling. Trump's speech does not constitute incitement, and the prosecution never even contends that it does. Indeed, the prosecution ignores the point entirely by failing to identify any alleged violence or to demonstrate that Trump's speech caused or was otherwise directed at inciting or producing violence. And they failed to explain how the gag order is narrowly tailored to prohibit those statements further. And so therefore, the gag order is in fact unconstitutional. And we'll keep going a bit. This is good stuff. They say the gag order also violates 2 more fundamental principles of the First Amendment. 1, the protection of President Trump's campaign speech meriting the highest level of protection. In the middle of a campaign, they had timed it perfectly. And let's not forget, by the way, this case is scheduled for a trial on March 3rd, I think, the day before Super Tuesday, whatever that Tuesday is. The day before, January 6th trial, before everybody's voting. They're going to get a big smack in the face by everybody. New York Times for the full week, 2 weeks, Trump's trial, Trump trial, Trump trial, coming up. Then the day they go into the voting booth, opening arguments probably. So 2, the right of President Trump's supporters and adversaries to have an equal and reciprocal right to receive his speech. I want to hear from him about this. I want to hear and see what's going on inside the courtroom. I don't trust any of these third-party hands from the government telling us what's happening. We want to see the documents and we want to see what's inside. And we want to make informed judgments about the presidential election. Now, on the former point, the Supreme Court has emphasized that the freedom of speech has its fullest and most urgent application precisely to the conduct of campaign campaigns for political office. If we're going to need free speech anywhere, that's where we need it, so that you can challenge the status quo, petition your government for a redress of grievances. Silencing the speech is the most anti-American thing that they can do. Now, they're giving us a bunch of case law here, and so we're fast forwarding. They say, but this court has repeatedly stated that it will ignore the obvious fact that Trump is a candidate for president. And we've seen that here. It's going to be treated like any other defendant. I don't care. We say he's not like any other defendant. He's the president and was at the time when all this happened. And that puts him in a different category of other defendants. I know they don't like that, but it's true. Now, in following this flawed approach, the gag order fails to consider that the allegations in the case are themselves political questions discussed at length by the media. Trump's prosecution in and of itself is a political issue. The whole thing. So President Trump's political opponents, some of whom are witnesses, are involved, like Mike Pence, and he's out of the race now, but Mike Pence, the Biden administration, and the citizenry writ large in connection with 2024. This is precisely where the gag order runs headlong into unconstitutional shoals. President Trump is absolutely entitled to defend himself publicly and explain with specificity why the charges against him are false and meritless. That is not, quote, trying the case in the media, as they say. It's called political campaigning. Hello, our most sacred and inviolable category of protected speech. The prosecution, likewise, gives the short shrift to the American electorate itself. That's us. They're screwing us, man, including President Trump supporters. First, the prosecution contends that Trump did not raise his audience interests in opposing the gag orders. That's not true. We did. President Trump raised this issue multiple times, both in our briefs and oral arguments. We said that the gag order would prevent Trump from presenting his side of the story to the American people during a political campaign. Verbatim. We said it again here, and again here, and again here, and again here, and again here. So don't say that in your stupid brief when we said it 50 times. Substantively, the prosecution's only response to this problem is to point out that the gag order doesn't silence all of Trump's speech, though. He can still say some things so that his listeners will get some of his speech. Isn't that nice? Don't you feel privileged to get some of Trump's speech from these deranged thugs? Now, again, the prosecution cites no cases to support this argument, and for good reason, because it directly contradicts the Supreme Court precedent. For example, in this case, the Supreme Court rejected a restriction on campaign speech that prohibited candidates from discussing their views on disputed legal or political issues, because that's insane. Likewise, there's some other examples of this. And so this portion also violates American freedom, the core freedoms, and therefore is unconstitutional. Now they carry on, they say, we also cannot rely on speculation that a third party is going to do something to justify the gag. Preventing unsolicited third-party, quote, harassment or threats, like they're saying, Trump's going to say something and somebody's going to do something, is not a compelling government interest under any circumstances, and it's wholly incapable of overcoming both the First Amendment right of a presidential candidate, his right to speak on a matter of public concern, and our right as the public. Our rights. And I want to be crystal clear about it. It is our right. They're also violating our rights to hear what Trump has to say. But even assuming, arguendo, that the compelling interest could not exist, the prosecution has utterly failed to establish it. They contend that they have uncontradicted filings that provide the need for the basis to establish the existence of harassment or threats. But the prosecution is wrong. First, screenshots of social media posts from, quote, between the presidential election and the certification on J6 almost 3 years ago did not prove that anyone has even been harassed or even threatened due to Trump's statements. Although the prosecution provided public statements from 3 individuals claiming that they allegedly received harassments, okay, so these randos, and threats in the same time frame, the prosecution did not draw any causal connection between these claims and Trump's statements. So Trump is not even connected to them, nor could the prosecution do so. Countless others made statements regarding the same individuals during the same time frame. So you can't causally connect it to Trump because Trump's commenting on things that other people are commenting on. Moreover, President Trump's statements, again, did not direct or request any harassment or threats at all. So the prosecution cannot say with any degree of certainty why such alleged events happened, if they even did, if you believe them. I don't. And that they would have not occurred but for President Trump's statements. And this is a legal concept, but for. Would any of this happen? Like, in other words, if Trump didn't say something, are we 100% certain that the consequences that they're alleging would have been avoided? No, of course not. Now, this, of course, is why the Brandenburg test is so stringent, because it's just speculation. It's purely speculation. So the prosecution provided screenshots from Trump's tweets, like, oh, wow, illegal speech. And its reply brief that proposed the gag order, they also cited other interviews, right? All these, September 5th, 6th, 22nd, blah, blah. And then they also referenced a Mark Meadows post, which Judge Chutkan is going to talk about. And for these posts, the government's case is even weaker. Jack Smith presents no evidence or even argument that any prosecutor, any court staffer, any potential witnesses has actually actually, okay, it's all theoretical, received any threats or harassment after public criticism by Trump, or even, quote, felt. They couldn't even find somebody who felt threatened. To the contrary, the prosecution stated that Trump's baseless attacks on the court and two individual prosecutors could subject them to threats. Baseless attack on the prosecutors. And we already know this, okay? Anytime that they use the word baseless, it's the opposite of it. The election was baseless. You know, all of our claims are usually categorized as baseless by their side. So here we know that they're not. Trump is legitimately attacking these institutions because they are losing legitimacy. Now, the prosecution has presented 17 examples of Trump's posts, and the prosecution presents no evidence of any ensuing threats or harassment. So Trump makes a post, somebody says, I saw the post and I went and harassed or threatened somebody. There is no evidence that any potential witness even feels threatened, however subjectively. But when the court asked the prosecutors why it had not submitted evidence of threats, harassment, and witness intimidation, the prosecution even admitted that its prediction of prejudice is speculative. We're just making it up. We're not real sure. And so they're going to go through a lot more case law here, but I want to skip forward because we still need to hit the judge's order. So we fast forward through the rest of this. We see we got some of the big meat and potatoes out of the way, but they're telling us, Your Honor, the prosecution's undeniable goal is to silence its primary political opponent. Trump, during his campaign against Biden, is happening right now. The court should not countenance such a blatant and unjustifiable attack on the First Amendment, and so accordingly, the court should deny the prosecution's bond modification request and stay the gag order pending appeal. So good arguments. And again, we're going to see those come back again in the future. We're going to see this come into a head. Free speech versus the criminal justice system. So that was Trump's argument. This was Judge Chutkan's order, denying the stay of the gag. She says, all right, everybody, deranged thugs and Trump. You know, on September 15th, the government moved for a gag order. Following the motion hearing, the court prohibited the parties from making certain statements. And now we move for a stay. Trump wants this gag order lifted, but that is now denied. Gag order's back. Trump responded right away. We'll see what he says. So they say, the judge says, all right, 4 factors guide the decision about whether to stay an order pending an appeal. And these are not that interesting, okay? They just talk about whether it's going to be successful or not on the merits. Or, you know, if they'll grant the stay if the judge thinks you're going to win, but the judge issued an order that she probably thinks is pretty good, which means she probably thinks it's not going to be successful on appeal. So she's just going to, you know, go through these factors and just reimpose it. But she does give us some rules and tells us what she's going to be analyzing. She said, Trump's claims disregard the record. Trump asserts that the court cited no evidence in supporting the finding of risks or harassment or intimidation. But that's not true. They say several times the court and the government pointed to evidence causally linking certain kinds of statements with those risks, and defendant never disputed it. So the kind of statements with those risks, is the risk the same thing as an actual threat? I don't think so. Now, when Mr. Trump has singled out certain people in public statements, hasn't that led to them being threatened, harassed, as demonstrated in the statements? Your Honor, says Mr. Lauro, that's totally irrelevant. And the government's motion cites several of them who averred that the kinds of statements that you've asked for under oath and threats and harassment to them had increased significantly as a result of Trump's statements about them. And they say undisputed testimony cited by the government says that when Trump has publicly attacked individuals, they get threatened. So the judge says, well, the evidence is in the record. He just fails to acknowledge it. So they're saying that, I guess, we have some relationships here. When he has publicly attacked on individuals, and this is from the judge's order, so the judge is citing her own order on this one, order at 2, and saying that they're failing to dispute or discuss the testimonies. All right, so this will all be appealed, obviously. Now, likewise, Trump claims that the court gave no meaningful consideration to other less restrictive measures like a narrower order. Again, that contradicts the claim that we see in the record. During the motion hearing, Chutkan says, I question whether Trump's existing speech restrictions, like his conditions of release, would adequately prevent the dangers to these proceedings. Could we just use his release conditions? Would adequately prevent the dangers to these proceedings. So she says, I did consider something else, his standard release conditions that a standard criminal defendant gets. The court also considered whether alternative measures could prevent the harms, and in fact concluded they could with respect to certain kinds of statements, like those disparaging DC. So you can comment about the geography, the city, but not about the politics at all. Thanks, Judge. So accordingly, the court denied the government's motion in those respects, but the court explained that alternative measures would not sufficiently mitigate the risks from other kinds of statements, like those targeting reasonably foreseeable witnesses. They say voir dire, jury sequestration are sufficient to remedy only some of the potential prejudices. Thus, the court tailored its order to prohibit statements only where less restrictive measures would be inadequate. Judge says, finally, Trump's final claim is that the order is unconstitutionally vague, but that's not going to withstand scrutiny. She went through Merriam-Webster's dictionary. She says an interested party the definition of interested to conclude that the term interested parties could include everyone affected by or involved in the case, which is broad, right? Everyone affected by or involved in the case. But interested party is a well-established legal term of art, meaning anyone who is both directly interested in a lawsuit and has a right to control the proceedings, going to Black's Law Dictionary. And this order confirmed that scope, and so there was no meaningful basis to interpret, quote, interested parties, my order is not too overbroad, as covering anyone else. So you should know what that means. And second, Trump focuses on the prohibition of, quote, targeting certain individuals. Again, quoting various dictionary definitions, saying that this leads to vagueness. But the motion and the order that Chutkan says she wrote provide substantial context for the types of statements that I mean. Indeed, the court identified that depending on their context, statements matching each of the definitions that Trump proffers could pose such risks. Things like Bill Barr's a smart guy, but he better learn to keep his mouth shut. They say 2 of Trump's social media posts since the order also illustrate the differences between the statements. So the judge is going through Trump's statements. She says, after the order was entered, but before it was administratively stayed, Trump said this: does anyone notice that the election rigging Biden administration never goes after the people who rig things, but only after those that want to catch and expose the rigging? Massive information and 100% evidence will be made available during the corrupt trials started by our political opponent. We will never let 2020 happen again. Look at the result. Our country is being destroyed. Make America great again. The judge says, well, Trump said that this statement says Trump is innocent and that his prosecution is politically motivated and that Biden is corrupt. It does not violate the order and the prohibition of targeting certain individuals, and this order permits that. So Trump is allowed to say this. He has some free speech. That's neat. But by contrast, after the order was stayed, Trump's language changed a little bit. It sounded like this: I don't think Mark Meadows would lie about the rigged and stolen presidential election merely for getting immunity against persecution by the prosecution, by deranged prosecutor Jack Smith. Boom, there it is. But when you really think about it, after being hounded like a dog for 3 years, told you'll be going to jail for the rest of your life, your money and your family will be forever gone, and we're not at all interested in exposing those that did the rigging. If you say bad things about that terrible monster, Donald Trump, we won't put you in prison. You can keep your family, you can keep your wealth, and perhaps if you can make up some really horrible stuff about him, we may very well erect a statue to you, right in the middle of our decaying and our very now violent capital, Washington, D.C. Some people would make that deal, but they are weaklings and cowards, and so bad for the future of our failing nation. I don't think that Mark Meadows is one of them, but who really knows? Make America great again. Judge says, well, that statement would certainly violate the order under any reasonable definition of, quote, targeting. Do you think it's important that in America we know whether or not our corrupt DOJ is twisting people's arms to make their case against a presidential candidate? Wouldn't that be useful to know? Wouldn't you like to know what Trump has to say about this? Because Mark Meadows was Trump's chief of staff, by the way. And we know Mark Meadows wrote in his book a bunch of things and did a bunch of work for Trump. So if he suddenly flips, shouldn't Trump be able to comment on that and say, well, you know, maybe that witness is not accurate because they are trying to flip him to take me out of the political game? But she says no, that's targeting. Indeed, Trump appears to concede as much. They say if the gag order had been in effect, President Trump would have been unable to make the statement. Well, that's true, but that doesn't mean that it's legitimately a gag on his free speech. It's still an illegitimate gag. He should be able to say those things. She says, and for good reason. The statement singles out a foreseeable witness for the purpose of characterizing his potential unfavorable testimony as a lie made up to secure immunity, and it attacks him as a weakling and a coward if he provides that unfavorable testimony. Well, okay, so does that mean nobody can talk about Mark Meadows at all? Should the media not be allowed to talk about Mark Meadows? What if they say he flipped and he's a hero and he's doing great work and Mark Meadows is a savior of America for finally exposing Donald Trump? Is Mark Meadows just off the game? Should the order also include Judge Chutkan gagging the Washington Post from getting leaks? So only Trump cannot have an opinion on these people, but everybody else can? This is an attack, says the judge, that could readily be interpreted as an attempt to influence or prevent witness participation in the case. The plain distinctions between this statement and the prior one, apparent to both parties, demonstrate that far from being arbitrary or standardless, the order's prohibition targeting statements can be straightforwardly applied and understood. So she's saying, yeah, Trump knows the rules. Okay, Trump's not a dummy. He's following my gag. And because he can follow it, she says, I like when I can control his speech to stop this. This is okay, but this is not okay. So Chutkan is now the little speech judge, saying defendants' other assertions of vagueness boil down to similar objections that deciding whether a statement violates the order will be a fact-bound inquiry. They say it's difficult to tell whether somebody's a reasonable, foreseeable witness and distinguish different attacks and different statements. But even assuming that's true, it does not follow that men of common intelligence must necessarily guess at the meaning of the order. She says you can understand it. It's not vague. The fact that he needs to speak with special care in close cases does not deny the order as being unconstitutional unconstitutionally vague. So if Trump has to tiptoe around his free speech rights, that's okay with me. So he's failed to make a strong showing that he is likely to succeed on the merits of the appeal, and therefore the remaining factors rule against the stay. Trump's brief arguments on each rely on the premise that his First Amendment rights have been violated. But she says, not true. The court finds that the public interest in orderly administration of this case requires the limitations on Trump's speech. For those reasons, Trump's requests are denied and the stay on the gag is lifted, which means the gag is back in effect. And so Trump's free speech rights, yet again, are removed by Judge Chutkan, based out of Washington, D.C., premised on some local rule, and for the sanctity of her courtroom in a highly partisan political hack prosecution taking place in one of the most biased jurisdictions in this entire country. Trump can't speak about it because they don't want him to talk about this. If he talks about it, they're going to be exposed. So Trump responded to this immediately, right after the stay was lifted, and he dropped a couple of responses. He said this: why didn't crooked Joe Biden tell his Injustice Department to file lawsuits and indictment against me 3 years ago instead of right in the middle of my campaign for president? You're setting a bad precedent for yourself, Joe. The same can happen to you, buddy. These third world Biden indictments, which should never have been filed, would have been tried over with years ago. My sleazebag opponent shouldn't be able to do this during my campaign or before the election. Says very much the same thing in that truth. And there was, I think, one more that I saw from him. Says the Obama appointed federal judge, right, going after the judge herself, says a true Trump hater, Chutkan, is incapable of giving me a fair trial. Her hatred of President Trump is so great that she has been diagnosed with a major and incurable case of Trump derangement syndrome, and says, I have just learned that the very biased, Trump-hating judge in D.C., who should have recused herself due to her blatant and open loathing of your favorite president, me, has reimposed a gag order, which will put me at a disadvantage against my prosecutorial and political opponents. This order, according to many legal scholars, is unthinkable. It legally and unconstitutionally takes my First Amendment right of free speech in the middle of my campaign for president, where I am leading against both parties in the polls. Few can believe this is happening, but I will appeal. How can they tell the leading candidate that he, and only he, is seriously restricted from campaigning in a free and open manner? It will not stand. And so the battle continues. They're going to try to continue to silence Trump. We know the media wants access to the courtroom. We doubt that they get it. We'll be here to continue to unpack all of these orders and more. And so I hope you join us as we do. Head on over to robertgovea.com to sign up for our daily newsletter. And that way, if you miss anything here on the channel, you'll get the email delivered right to your inbox where you can stay apprised of all the latest happenings in this case and more. And we'll look forward to seeing you on the next one.